All right, so welcome to the first virtual lecture. We're going to talk about sort of an overview of criminology and the criminal law. I'm not going to lie to you, it's probably among the least sexy topics that we have in criminology, but it's important to sort of lay a foundation for the course before we move on to some of the more interesting stuff. I guess the starting point is to define what exactly criminology is. And from that, we take Eddie Sutherland's definition of criminology as the scientific study of lawmaking, lawbreaking, and the response to lawbreaking. So lawmaking is about how laws are made and changed. And so, good example right now is the status of recreational marijuana use. So, 200 years ago, it was legal. We criminalized it at the start of the 1900s. Now states, some of them are decriminalizing it. The federal government still has it as criminal. So, there's a body of literature on how things come to be criminalized and how and why that status changes. Law breaking refers to sort of the bulk of what criminology is about, and that is sort of the nature and extent of crime and why people commit crime. So how much crime is there and why do people commit crime? Reaction refers to our criminal justice system. So you can use scientific observations to study the police or the courts or our correction system. So, police right now, there's a big debate about police use of force, especially lethal force. So you can collect data on how much police use force, under what context, and those sorts of things, which we will talk about in policing. Corrections, you think about, the extent to which offenders can be corrected or rehabilitated, and there's a scientific literature on how well that works. So the important part is we're using science versus sort of other ways. We come to sort of know and understand the world through a variety of sources. A lot of it is media consumption. Some of it is sort of just anecdotal evidence. Anecdotes are just stories somebody tells us. So somebody tells you something from their experience, and you sort of absorb that. In contrast, science is a very sort of structured way of gaining knowledge to understand the world. So it's use of direct observation and specific protocols for collecting data and how we interpret it. So that's the gist of what criminology is. People ask me how that differs from criminal justice. You can get a degree in criminal justice, you can get a degree in criminology, and honestly, the same sorts of folks like me teach both places, and so you tend to get the same information. Criminal justice programs tend to focus more on the agencies, so police, corrections, whereas criminology tends to focus more on the nature of crime and causes of crime. But, it's two sides of the same coin, because in order to sort of respond to crime, you have to understand what causes it. In criminal justice, if you do things, so take, for example, offenders, you do a rehabilitation program where you fix something you think causes crime, and it works. Well, that tells you, from a criminology standpoint, that was a true cause of crime. So changing it made people less likely to engage in future crime. So there's not a whole lot of difference. There is a fair amount of difference between criminology and the discipline of deviance. So criminology focuses only on sort of areas of deviance that are actual violations of criminal laws. Deviance focuses on violations of any social norms. So these norms may or may not be law violations. So if you think about norm violations that are not law violations, picking your nose, having a child out of wedlock, and they range from the sort of less serious to the more serious. And you can, and sociologists have sort of graded norm violations of folkways, mores, based on sort of the seriousness of the response. So less serious norm violations result in sort of a bit of ridicule. You get caught in a nose pick, you might get laughed at or ridiculed. Whereas if you have a child as a teen out of wedlock, it might generate sort of more serious responses. There are, you can think of some law violations that don't necessarily violate a norm. Try driving down the interstate highway at exactly the speed limit, or on a city street exactly the speed limit, and see how people respond to you, right? That the norm is that people drive faster than the speed limit. So that's the difference between criminology and deviance. In terms of the law, it's really only time right now we're going to spend talking about the criminal law in any detail. There are sort of two bodies of law out there, criminal law and civil law. And generously, civil law is usually defined as everything that's not criminal law. Civil law would include things like contract law, patent law, property law. The only sort of area that overlaps with criminal law is something called tort law. And then the criminal law, you have procedural versus substantive and statutory versus common. Substantive law is the actual code that define crime and punishment. So every state and the federal government has laws that are codified. So it'll tell you in a book that X and Y behavior are illegal, and they'll define what that behavior is, and they'll specify the punishments for people who get found guilty of those crimes. So that's the substantive law. That's the written codes. So there's a Minnesota state code that defines everything that's illegal. Procedural law is law that governs the criminal justice system. So when you talk about police, when can police search your vehicle? So if you get pulled over, can they just take you out of the car and immediately search your vehicle? The answer is it depends. They can if you give them permission to search. Otherwise, they generally need a warrant unless there's some exceptions. For example, if there's a giant stream of marijuana smoke coming out of your car when you roll down the window, that gives them cause to search your car. So procedural law are those laws that sort of govern what the criminal justice system actors can do. As I said, there is a sort of body of civil law that runs parallel to the criminal law. So, I guess our most famous case in the U.S. is the O.J. Simpson trial. So O.J. was tried for murder in the criminal justice system and found not guilty. He was subsequently sued in the civil courts for wrongful death, and that case he was found liable for wrongful death. So generally, tort law and criminal law cover the same sorts of behaviors. So murder in criminal law, wrongful death in tort law. But there's a bunch of differences. Tort cases are brought by private parties, whereas criminal cases are prosecuted by a government entity. If you win in tort law, the person doesn't get sort of punished by a prison or death. They get punished. The sanction is monetary damages. So at best, you can win for money in tort cases. One of the big differences is the level of proof necessary. In the criminal law, the burden of proof is beyond a reasonable doubt. That's a pretty high standard to meet. Defense attorneys and prosecutors will sort of banter about what is that, but generally, 90-95% sure would be proof beyond a reasonable doubt. In contrast, the tort law and civil law generally requires only the preponderance of evidence. So you have to be 51% sure in order to decide a case. So it's one of the reasons, by the way, that a lot of corporate crime is pursued using civil law rather than criminal law, because those are very hard cases to prove criminal intent beyond a reasonable doubt. And so when you hear about big civil settlements, that happens because civil cases are easier to prosecute. All right, in terms of crimes, there's a few ways to classify crimes. One of the most general distinctions is the mala in se versus mala prohibita. Mala in se roughly translates into wrong or evil in and of themselves. So these are crimes that have been enforced in almost every society across all times. So in virtually every society, it's been wrong to kill another person or to forcibly take their stuff, which is robbery. In contrast, mala prohibita crimes, the loose translation is they're wrong because we say they're wrong. And those are crimes that differ across societies and across time. So my example of marijuana earlier, that would be a very classic example of a mala prohibita crime, that some societies criminalize marijuana, some not. In our society, we've sort of switched over time. Other examples are prostitution and gambling. The other classification of crimes that's very common in the U.S. is between felony and misdemeanor charges. So legally, a felony crime is any crime that's punishable by imprisonment for more than a year in a state prison. For misdemeanor crimes, the punishment is less than a year in prison. So some people make the mistake of assuming misdemeanor crimes are, very petty and result in almost no punishment. But for a lot of misdemeanor offenses, you can spend almost up to a year in jail. So that's the difference between felony and in every jurisdiction they have grades. So you can get felony 1, felony 2, felony 3, and misdemeanor and gross misdemeanor, and those sorts of distinctions as well. The body of criminal law, in order to show somebody violated the law, you have to have both actus reus and mens rea. The actus reus is the physical act. So almost all the laws define it as somebody did something. And it has to be voluntary. There are some failure to act crimes, but generally speaking, for a failure to act crime, there almost always is some sort of obligation. That is that you entered into a contract to do something and you didn't do it. So a classic example is a lifeguard that refuses to jump in the water and save somebody. So their failure to act as a lifeguard can be criminal because they signed up to do that job. There are some states that have so-called Good Samaritan laws. So if you pass a car wreck and do not stop to render aid, that you can be held criminally liable for that failure to act. Intent can be general or specific. So you have to, in order to prove somebody committed a crime, you have to show they intended to commit the crime. The general versus specific. General intent means simply they intended to commit the crime you're talking about. Specific intent refers to some individual crimes that require a special form of intent. The classic one is burglary. So burglary is defined as breaking or entering into a house with the intent to commit another crime. So usually that other crime is theft. So in order to prove a burglary case, you have to show they broke into somebody's house with the intent to take their stuff, which is different. So, my example is always my older brother. They imbibed way too much alcohol one night, and my brother woke up in the morning with some guy kicking him, holding a baby, like, what are you doing? And my brother said, what are you doing in my house? And the guy's like, what are you doing in my house? And it turns out he went in the wrong door. Actually the completely wrong neighborhood. So that's an example of maybe breaking and entering, but certainly not burglary. He had no intent to commit any other crimes. His main intent was to sleep without trying to puke. So that's specific intent. There is a doctrine of transferred intent. It actually comes, I can't remember who the assassination attempt was. It comes from a very old case in England where there was an assassination attempt, missed the target and killed somebody else. And the legal claim was, well, I didn't intend to kill that person. I just had bad aim. And so that led to the doctrine of transferred intent, that if I do a drive-by and I shoot at somebody and miss but kill somebody else, that intent to kill the first person transfers over to the second person. You can have offenses where people did not intend to cause harm, but they get found guilty of negligence. And basically that's doing something that a reasonable person knows could cause the harm that was actually caused. So you drink and drive. You didn't intend to kill somebody. You didn't set out that way. However, reasonable people know that if you drink a lot of alcohol and get in a car, there's a chance that you could do that. Strict liability offenses refer to things that don't require any intent. So traffic laws, right? So you don't mean to speed. You weren't paying attention. You had no intent to do that. But for those offenses, there's no need to show intent at all. So that's the sort of necessary elements to show a crime has happened. In terms of defense, you can sort of do two things. You can deny that you did the offense, or you can deny that you had the intent necessary, the criminal intent necessary. Um, and so, generally speaking, there's not a lot of good defenses. Ignorance is no excuse for violating the law. Everybody's expected to know the laws. Intoxication, like, well, I didn't know right from wrong because I was too drunk. The problem is that people know that if you drink, you can make bad decisions. So you did decide, you did intend to drink and get drunk. The insanity defense is probably one of the more misunderstood ones. Insanity defenses are exceptionally rare. They almost never work when people bring them up. And if you win an insanity case, you don't get out of prison or jail. You end up getting put in secure custody in a mental facility. And the research suggests that you're going to stay there longer than you would have stayed in prison. So insanity is a legal term, and sort of how it's applied varies by state, but generally the idea is whether you're mentally capable of knowing right from wrong. So those are the defenses. So we're going to sort of move on from the more specific legal stuff and talk a bit about the law generally. And this is a point that comes up a few times in criminology. One of the issues is who the law serves, who's it designed for, and sort of how does it come about. And there's sort of two general views that are usually pitted against each other. The consensus view suggests that laws is a result from things that were social norms that a lot of people agree upon, and there's so much agreement that they become codified in a body of law, and that the laws are there to apply to everyone equally, and that if there's any bias in the law, it was sort of unintentional, and it tends to be temporary and wash out. In conflict, the conflict view suggests that law is a result of a sort of battle over ideas, and that people who win the battle over ideas get to say what's legal and what's not, and they often sort of criminalize the acts of the people that they were against. Which is right? Like a lot of answers to things in criminology, it depends. So if you think of a law like homicide or the other mala in se crimes, there's not a lot of disagreement that homicide should be criminal. But when you get to the mala prohibita crimes like gambling or prostitution or illicit drug use, you do see some conflict. You think of something like abortion or gun control laws, right? You have a battle of ideas over what should be legal and what should not be legal. And if I'm a person that believes abortion is equivalent to genocide, then if I get my way and I get the power, I'm going to criminalize abortion, and that may have a negative impact on other people. In contrast, if I'm somebody that believes in abortion rights and that abortion should be not criminal, that's what I'm going to make happen when I get in power. So that's a theme that'll come up a few times. All right, so the other way to sort of look at criminology is to think about it as a sort of academic discipline. In that sense, it's a newbie. Until the 70s, universities didn't have a criminology or criminal justice degree. By and large, you had to get a sociology degree or maybe a psychology or political science degree with an emphasis on something like deviance. There has been sort of a mini explosion since the 80s. Criminology sort of emerged as a separate entity. UMD just this last year finally added criminology to our department. Prior to that, it was just a sociology and anthropology department, and we offered a degree in criminology. So criminology sort of slowly emerged as a separate entity throughout the 80s and 90s. And there's still some debate about whether it's a sort of real discipline. And I get, it makes a bit of sense. So if you think about what psychology is or biology or sociology, they're kind of a way of looking at the world, a way of using science to examine some domain. So psychologists tend to look at individual differences between people in terms of like intelligence and personality and learning. Whereas sociologists, for example, tend to look at group processes. And political science obviously looks at politics and how politics shapes the world. In contrast, criminology is less sort of a way of looking at things and an area to look at. So it's a class of behaviors, and in that sense, it's sort of interdisciplinary or multidisciplinary in the sense that you can examine crime from psychology perspectives, biology, sociology. It's all stuff we're going to get to. So in that sense, it's a bit wonky or weird compared to other disciplines. For the past probably 40, 50 years, sociologists have dominated criminology. So most of my professors in graduate school were all sociologists. The upside of that is that there's a healthy focus on sort of bigger picture things and social structure and equality and things we don't necessarily sort of see at first pass when we look at crime. And sociologists tend to do a very good job of kind of debunking myths, things that people believe that are true turn out not to be true when you sort of understand them through science. On the downside, sociologists have tended to be sort of protective of sociology as the way to study criminology. And so they have tended to kind of ridicule outside disciplines, especially biology and psychology. And that's unfortunate because most biologists and sociologists would say, look, like, a biologist would say, we're studying genetics and central nervous system, but that can only play out in some sort of context, so what they're saying is you need that social context and sociology to help explain biology. So we're going to talk in this class about all kinds of approaches to crime, psychology, biology, so on and so forth. In terms of how criminology emerged, study of crime emerged, 1750 is essentially colonial America. And really up to the end stages of colonial America, the prevailing sort of theory of crime was what people refer to as the demonic perspective. That is that, crime is caused by forces outside of a person's responsibility, that essentially crime was sort of viewed as God's will. So for good or bad, all your outcomes in life are viewed as a result of God's will. And sometimes specifically as a result of some sort of demonic possession. In that sense, colonists didn't really see crime as a social issue, as a problem that could be solved. It just is what it is. And it made no sense to try to reform people because, what was happening was simply the result of God's will. That all starts to change at the end of colonial America, at the start of the Revolutionary War. And what ushers in that big change is, it's a variety of things, but really this classical school emerges that emphasizes that human beings have a certain amount of free will, that they still wanted to tether it to religion, that God grants us a certain amount of free will. And because of that, human beings essentially choose crime. And the argument became that, well, if that's true, if human beings are sort of rational and they choose crime or not crime based on their environment, we should be able to manipulate the environment in a way to sort of coerce people into choosing not crime. So they argue that if you reform the legal code, that the legal code at the time would make little sense to us now, that pickpockets were sometimes hung, common thieves were hung, murderers were sometimes let go. It depended on the circumstance, that you could coerce confessions, that you could sort of make up crimes after somebody had actually committed the act. So a judge could sort of retroactively make your behavior criminal. The argument was if you sort of rationalize the legal code, and that became the basis of the American legal code after a revolution. We wanted a sort of more sane, rational, humanistic legal code. That they really believed that you have less crime and perhaps you could sort of make crime disappear. The classical school as a sort of theory of crime it's our first science theory because you can actually test it. It's a pretty crude theory. Why do people commit crime? Because they choose to do it. Um, but you can test it, right? Like if the punishment for crime is more certain, then you should see crime go down. We'll talk about that later in the semester. Um, the positivist school emerges in the 1900s as a result of sort of increase in the use of science to study crime, the so-called social sciences like psychology and sociology. Um, and it's the belief that crime, like other human behavior, is caused by all sorts of outside forces. That's a belief in determinism, that human behavior is in large part determined. And the cause depends upon, how you look at crime. So sociologists would say it's caused by social forces like poverty or racism. A biologist would say what's caused by, low arousal, which is dictated by genetics and central nervous system. A psychologist might say it's caused by like a personality construct, like low self-control. But regardless of sort of how it's caused, the solution then becomes, well, fix the causes, right? So, and it leads to sort of more science to understand what the causes are. So there are, down here, different flavors of positivism, right? And each sort of had their heyday in criminology. Our earliest deterministic, positivistic theories were in biology and psychology. As I said, sociology came to dominate the field. And the most recent entry is something called developmental theory that sort of tracks different causes over people's life course. Regardless, the sort of common theme is that crime is caused by something that we can identify through science and potentially change or fix. Which gets us to these sort of theories of crime. That crime theories are kind of the backbone of criminology. That scientific theories help guide inquiry and help make sense of the data we collect. And so it makes sense now as sort of laying groundwork to talk a bit about what makes a theory good. In order to be a theory generally in science, it has to be testable. So a not testable theory, for example, might have concepts in the theory that can't be measured. So my lame example in the book and in classes face-to-face are the little green man theory, right? So my theory is that little green men live inside your head and whisper you do bad things. And I said, well, it's unfortunate, but little green men can't be CAT scanned or X-rayed or MRI. They're immune to all those sorts of tests. Well, as a theory of crime, it's useless because nobody can measure little green man activity. That's a stupid example, I know, but it's not a big jump to go from little green men to something like a conscience. People say, well, lack of conscience causes crime. Criminals lack a conscience. Well, can you measure somebody's conscience? Can you test that sort of theory? And if you can't, that theory is just as useless as the little green man theory. So good theories are ones that are stated clearly and can be tested out in the real world. Good theories survive all that empirical testing. It's kind of a funky way to think about it, but we subject theories to what's called falsification, right? And so we try to prove theories wrong in science. And a good theory essentially survives all those attempts to prove it wrong. So at the starting point, you say, well, good theories are ones that are supported. And that's true, but in social sciences and criminology, it's very rare to find a theory that's always supported or always not supported. And so what you're looking for is sort of what's the balance of the evidence. And I try to give that to you, both in the book and these lectures. It's part of my job is to kind of give you some sense of where the weight of the evidence falls. But assuming a theory is supported, that it's right, you get down to kind of the second stage, and that some theories are sort of preferable to other theories. And so parsimony refers to using few concepts to explain something. So, you can have a theory of crime that says these 400 things are all related to crime, and it may be true, but as a theory, it almost becomes useless. At some level, you're saying, well, a bunch of shit causes crime, which if true, great, but it's not really helpful. Part of what theories are supposed to do is sort of guide you in how you respond to crime. So good theories don't say 400 things cause crime. They say these 2 or 3 things are crucial in a cause of crime. That's parsimony. Parsimonious theory uses few things. Scope refers to what you're trying to explain. And so you could need a theory to explain, burglary in lower classes amongst left-handed gang members. But that would be a very narrow scope. You're only explaining a little small slice of crime. A better theory says, well, I can explain all crime. White-collar crime, street crime, doesn't matter. I can explain all crime and deviance. So a good theory is one that uses very few concepts to explain a great deal. That's the combination of scope and parsimony. The last sort of criteria here is probably the more controversial. Some folks would say that every theory generates some policy implication. The theory tells you what causes crime. It tells you then how you might change crime. And some folks have said, well, some policy implications are sort of more useful than others. So the classic example is a Marxist theory of crime that makes the argument that capitalism is the root cause of all evil, including crime. Well, what's the policy implication? Policy implication is to end capitalism, and you'd have to do that by armed revolt against the government and institute a socialist state. Now, is that going to happen in the next 10 years in the United States? Probably not. And so how useful is that as a policy implication? Other folks would say, I don't care, right? If I'm right, I'm right. It doesn't matter how useful you think the policy implication is. And so that's where the controversy comes from. So if you put all that stuff together, you basically start with this idea that to be a theory, it has to be falsifiable. It has to be able to be tested. And if it's not a real theory. It's not a useful theory in science. If it is, the next big question is when we go out into the real world and we make observations and we test it, is it right? If it's completely wrong, you got to get rid of the theory or modify the theory. If it generates empirical support, then you can sort of judge the sexiness of that theory using these other criteria. Obviously, the sort of key linchpin here is empirical support. And so in social science, generally we're trying to establish cause and effect. And to establish cause and effect in the social sciences, you have to kind of prove 3 things. One is that the cause happens before the effect. That's the time ordering. So if you use poverty and crime as an example, you have to show that the poverty happened before the crime. And that's important, right? Because the second part is correlation, that poverty, which is our X, has to be related to crime. So it could be that poverty is related to crime, but that crime happens first, right? If you live in a criminal lifestyle, you sacrifice education and other sorts of things, you may end up in poverty. So it may be that they're related, but that crime causes poverty, not poverty causes crime. So you have to establish this comes first, and then that these 2 things are correlated. And the third thing is that you have to establish that these 2 things are not only correlated, but that correlation is not the result of some spuriousness. Spuriousness means that, while related, one doesn't cause the other. So the example I have out here is something you think of like low self-control. People who are very impulsive and lack self-control are both going to end up in poverty and be more likely to engage in crime. So poverty and crime would be related, but they'd be related because they have the same underlying cause, something like low self-control. Now, I'm not saying that's true or correct. I'm just using it as an example. So you have to sort of rule out somehow the spuriousness. And there's sort of 2 ways to do that, to try to establish cause and effect. The most kind of straightforward, ironclad way is to do a scientific experiment. And the key to experiment is random assignment of groups. That you randomly assign groups. Right here, you start with a bunch of people. Some get put in the experimental group, some get put in the control group. The randomness is key because at the start of this experiment, then these groups are equal. So they're equivalent on the things you might measure, like low self-control, and things you don't measure, like preference for Burger King or McDonald's. And it's critical because then you manipulate one thing. So if you have equal groups and you manipulate one thing and then you look at the outcome, we're really confident that any difference in this outcome data is due only to this, whether they were in the control group or the experimental group. So most drugs for medical use we test using this method, right? So we get a sample of people that have some form of cancer. Some of them get randomly assigned to the experimental group. They get some new experimental treatment. Others get assigned to the control group where they get essentially a sugar pill or a shot of saline or something, but no actual treatment. And then we look at the outcome. Did people who got the treatment, did they survive longer? Did they have less symptoms? We look at that sort of outcome data. If you see outcome data here that's consistent with your hypothesis, that's pretty powerful evidence of cause and effect, right? Like, what else could have caused this difference? These groups were equivalent to start. The only difference is one got a drug and one got a sugar pill. The problem with the experimental design in chronology is that a lot of things we're interested in aren't really amenable to this design, right? Like poverty. For this to work, you'd have to have a poverty condition and a no poverty, and randomly assign kids to poverty or not poverty. Well, that's not going to happen. There are sort of some workarounds. For example, anytime you do a manipulation of criminal justice or social policy, you can incorporate experimental designs. So one of the classic examples was a program called Moving Out, where they took people in really, really bad neighborhoods, and they gave them a chance to move out more towards the suburbs, more stable education, better neighborhoods. But they only had so much money, right? And so you had 1,000 families sign up to go out, and they literally just use a lottery, a random process to figure out who was going to get the program and who didn't. So that sort of approximate that same design, right? So you have some kids that families that moved out, some that didn't, and the only difference between those two groups was that these guys won the lottery and these guys didn't win the lottery. And then you look at crime data to see did it matter? What families performed better? You can also use this with any kind of rehabilitation program, right? So if I think low self-control causes crime, I design a program to increase somebody's self-control, right? And so I give some of the people the real treatment to reduce self-control. Other people get, I don't know, motivational speaker. And then we look at crime data. And so if you show that increasing self-control reduce crime, it's pretty powerful evidence that self-control is a cause, a true cause of crime. That said, most of our data tends to be generated from non-experimental design. We do survey research where, we measure people's poverty and crime, and then we try to sort of make sure the poverty happened first. So you can use longitudinal data. You can measure people year after year. You try to figure out, well, did the poverty happen first, or did the crime happen first, or delinquent peers? Do they start hanging around with delinquent kids first, and then they became criminal? And so you can establish the time ordering using longitudinal data. You can establish correlation using the information you collect. The problem is you can't rule out spuriousness in any clear way. And so to do it requires a great deal of mathematical measures, that you have to measure the things that you think cause spuriousness and then statistically control for them. And that can get hard to do, and it can lead to sort of iffy conclusions about your scientific research. Which raises the sort of last point, and that is that criminologists tend to be very cautious with empirical evidence. Every study is flawed in some way, and what we look for tends to be the triangulation of data. Different methods all sort of led to the same conclusion over time. That's the importance of replication, right? Replication. You sort of make sure that things are right. Politicians and media and the public tend to overgeneralize. There's one scientific study, and then it becomes a screaming headline in every newspaper that coffee causes cancer, coffee reduces cancer, or whatever it is. And that can definitely lead to bad policy. There's two here. Let's see. We'll pick the domestic violence experiments. So the first experiment was an experimental design. where police officers were given essentially flashcards. And when they rolled up on a domestic violence incident, they randomly picked one of these cards which said mediate, separate, or arrest. Mediate meant they tried to settle the dispute. Separate meant they made usually the guy take a walk, not return for 8 hours. And arrest means that there was evidence of physical abuse, they arrested the person. What they found in their initial experiment, which was done in Minneapolis, was that people who got arrested tend less likely to offend in the future. That's an important finding. It suggests that maybe we should be quick to arrest people. Before it could be replicated, that led to people creating laws across the country, the so-called mandatory arrest policies, where if police show up on the scene, somebody has evidence of physical harm, that police have to arrest. They don't have any discretion to not arrest. Unfortunately, when they went to replicate this study, it didn't work. They tried it in Milwaukee and they tried it in New Jersey and a couple other places. And in some of the places, arrests seemed to make things worse. It aggravated the act. So it's unfortunate because no policy comes without side effects. And one of the side effects of mandatory arrest was that more women started getting arrested. Right. So if you think about a physical dispute, people are punching each other. So if a woman tries to defend herself, she scratches the person. What happened is both people started getting arrested rather than one person. And so you see this sort of spike in arrests for female assaults that happens in the 90s, in 80s and 90s. Well, did women get more violent? No. We changed our policy. So that's why criminologists tend to be very cautious with conclusions. Politicians will say they want a one-armed criminologist because we're fond of saying, well, yeah, that's true, but on the other hand, blah, blah, blah. So, all right, I think that's a good place to end. We're going to break this up into two sections.